Welcome everyone to the second speaker in our webinar series, Great Legal Minds webinar series. So Bill, I have the honor of introducing him as a INBLF Silicon Valley member of our chapter. He is our corporate and transactional attorney. And he's really our guru. He's great. He answers all of our questions and really helps us out. He started practicing corporate and M&A in 1988. And he first went to Shearman & Sterling, LLP, followed by moving to the West Coast at Wilson, Sonsini, Goodrich, and Rosati. And he actually worked right underneath John Goodrich, who as his main right-hand senior associate. So little news about his background. He also ventured to Moscow, where he actually worked for the government in government service. So he has a very interesting background. And this all happened prior to him opening his own practice, which he does corporate and M&A work. He really likes corporate formations, financing, M&As, spinoffs, all that business stuff. He does, of course, what they call the regular contract type of works for his clients, but he really is crazy about and loves all the complex and really intricate details of corporate issues that come up. So he doesn't want to be bored. He wants to dive right in. So on that note, I'm going to let him dive right in and start his presentation for us. Bill?
Great. Well, thank you, Marcine. And Annabelle, thank you for all of your help in getting this off the ground, and mine in particular. So I appreciate that. So I'm really delighted to be with all of you in any circumstance, but particularly these circumstances when it's so important for us to be together. And it's, I've been really excited about being a member of INBLF for the opportunity to meet across the country and globe, but with whom I share something. So I'm really thrilled to be a part of this. So the talk that I'm going to present to you is based on a talk that I gave to a number of entrepreneurs in a tech meetup in early April. I'm in Santa Cruz, California, which is where I'm based. And as I was preparing for this, there have been some things that I've updated, but just the idea of looking at something from early April and trying to remember how far ago that feels, makes me think that the law is a very flexible thing. It's changing in some ways faster than we could possibly anticipate. And I guess that keeps us all on our toes. So the goal behind the talk, and really the goal of my talk with all of you today, is not so much to talk about the specifics of the law, but really to give you a sense of the kinds of things that I've been trying to counsel my clients on, in lieu of what I often do with my clients, which is just cups of coffee and chatting about what's going on in their business. And I felt it was important to help my clients understand what they could do proactively in these times to avoid what I sort of think about as sort of like a Pyrrhic victory of, your company has survived the pandemic, but you don't want to emerge at the other end of whatever this is or turns out to be, to have to discover that your company is unfinanceable, ungovernable, or unacquirable, because at least for the entrepreneurs, in our neck of the woods, the goal is acquisition. It's not, public. It's not IPO. It's getting acquired. It's Google's going to acquire us, Facebook, someone, and wanting to make sure that companies are doing the things that they need to, so that on the other end, they can survive as much as one might be able to. Rigorous due diligence by big firm counsel and specialists who come in. So my objective is more to help you develop, what I would call a few legal antibodies so that you can sensitize your clients and help steer them through this. When I talk to the entrepreneurs, I tried to give them a few trigger warnings. There's a couple of things that, we can talk about and that I've talked about with them that, they may not have thought about, and none of this was intended to, create panic among them if they hadn't thought through things. But we're all adults, and our clients are also adults, and there are just things to talk about that are important. And I recognize that a lot of you have subject matter expertise that extends far deeper into some of the areas that I may touch upon. I'd be really interested in your feedback, either as we go along, if you like, or at the end, because I think there are things certainly that I can learn from you. So one of the first things, and my first topic that I have talked about with my clients, and I think, if you're a lawyer in sort of the counseling mode in addition to sort of a transactional mode, it's a good thing to do. Or if you're not in sort of that counseling mode, I think it's a business development opportunity just to be able to call up some of your leadership teams and just talk them through these kinds of things. But the first area that I try to impress upon people is what I've called sort of cautionary words. And the first thing that occurred to me is the rule of law, and the rule of law persists. And we need our clients to understand that just because there are declarations of emergency at federal, state, or local levels or overseas, and there's a plethora of executive orders, that does not mean that the rule of law has been suspended. So corporate law, securities, contract law, antitrust, criminal, family, bankruptcy law, export control, privacy and HIPAA, tort law, fiduciary duties, all of these things still continue. They're with us. And yes, there may be some modifications or some accommodations, but these are all things that have been part of the body of law, are and will be. And I try on a daily basis, when I wake up in the morning, just to read all the things that come in on my phone and try to keep up with as many developments as I can in the legal world. It's obviously, and you're also trying to do that, it's really hard to do that. But I did come across a site that I thought would be important to you, which is developed by Stanford Law School, and it's called the Stanford COVID Memo Database. And if you're not familiar with it, I would commend it to you. It was developed at Stanford by the Rock Center for Corporate Governance there, and it's a collection of over 6,200 memos, searchable by law firm and by big accounting firms, by topic, and it contains two basic resources. One is just a database that will allow you to see firm by firm what each firm is putting out on COVID-19. And the other is the actual memo database itself, which is searchable and covers a really broad range of topics. Just as law covers all of society and the virus does as well, so too do these memos. And you can find them at covidmemo.law.stanford.edu. And it's, it's probably a good thing to look at from time to time. You can keep up with the latest learning that, big firms are spending lots of money to have, folks generate. And I've found it useful from time to time to take a look and just, stay informed. The other thing that I try to impress upon my clients is, what I sort of jokingly refer to as other shoes will drop. The rule of law persists. Our clients need to understand that it's not going to be a defense to very much of anything, certainly to claims brought by a plaintiff's bar behalf of people who suffer economic or physical losses, that while we're in an uncharted place, we're in a state of emergency. It's most likely not going to be a defense that it was necessary for us to do X, Y, or Z, or not to do X, Y, and Z in order to save our company or our employees or their families or our customers from ruin. And my feeling is that there are going to be other shoes that drop, other reactions equal and opposite to what we all do now. And I think it's important for people to keep that in mind to prevent or at least limit the possibility of liability in the future. And my thinking for this really originated with conversations I was having with some medical professionals who were really concerned that not only are they risking their lives to treat people, but the standards of care in medicine in a lot of places are just perhaps not even known for the kinds of circumstances they find themselves in. And they're sort of terrified that after all of this is when their troubles are going to start. And that made me think that, we can't assume that the judges, juries, district attorneys, prosecutors, and regulators of the future are going to be kind to anyone. There are going to be people who are injured who are going to, rightfully look to use the legal system to seek remedies. And no one is immune from these things. And therefore, my feeling has been to try to discuss with clients the need to be cognizant that we can get through this situation, and that may be when the real problems start for a lot of people who successfully navigate this, whatever that means. When I talk with founders, one of the questions that I'm asking them now is how they own their stock, and how others in their company own their stock. And I sort of think about it as like, the equivalent of estate planning for your corporation. For people who already have trusts, have they registered their share, the ownership of their shares properly in their trusts? If they don't have trust, I try not to alarm people, to suggest that now might be a good time to think about all of the things that go into estate planning, including issues relating to children, as well as their financial assets. But that conversation does come up, and at least in Santa Cruz, there's a number of estate planning attorneys who are glad to take referrals from people who are otherwise really stressed and not able to dedicate a lot of money to estate planning. But I feel like it's a value that we can bring, again, in that counseling role of just trying to make sure people are, well taken care of. And so, when I ask people about their stock, I try to talk to them about, if you've got your shares in a trust and something should happen, or if others who have controlling interests in your corporations have the shares in trust, it's going to make it easier, to get shareholder votes, to be able to make sure that, the shares don't have to go through probate, which might require, a lot of process and divulging information about valuation, and who knows what that would be anyway. It makes it easier knowing that there's continuity of ownership, so that if votes are taken, future, lawyers issuing legal opinions may have fewer issues, et cetera, et cetera, et cetera. So we try to have that conversation, the talk. The other part of the talk that I have with them, and this is particularly true with companies that have come to me after they've been founded, a lot of people have entered into shareholder agreements. And by that, I mean, I don't mean the kinds of documents that you would see like from the National Venture Capital Association, investor rights or right of first refusal agreements, things that have been, really well honed by the bar and in practice. But very often, at least my smaller clients come to me and some prior lawyer or accountant has given them some sort of shareholder agreement by which they have all, bound their fates together. And when I've gone back and looked at some of these things, my feeling about these agreements has been, by and large, they're not well drafted, and by and large, almost no one has ever read them. So they don't actually know what they have agreed to with respect to their shares in the event that they become disabled or pass away. And, while they all sort of expect, well, it must be good because someone gave it to us and we signed it. There's a lot of junk DNA, as we all know, that gets buried into these kinds of documents. And as I've taken a look at just a couple of the random shareholder agreements in my files, one of the things that has struck me is, if a person holding the shares, passes away, okay, the company may have a right to buy those shares, which most likely the company is not going to either be able to or want to perform, in which case other shareholders may have these springing rights to buy your founder's shares, and the valuation mechanics in the agreement may or may not be properly thought through. And part of what I encourage people to do is, not necessarily to go and try to amend these agreements, but to at least understand what they've agreed to, so that if there's something in the agreements that really doesn't work, and they're all still able to amend the agreement with something that they would prefer to have, that they can do that. So that's, those are some of the high-level topics just about the continuity of ownership. I do also try to talk to people who are directors and officers of my companies. Most of my clients are companies. I do, in a few cases, represent individual investors who may be on boards. And so I also try to have this conversation with them to emphasize that they have a duty of oversight, and it doesn't take very much imagination to come up with all sorts of scenarios which 6 months ago might have been crazy, and today or next month might be run of the mill, where oversight is more important and more challenging than ever. And my feeling is that risks that are faced by corporations are being exacerbated by just about everything, from the pandemic to politics, from safety to supply chain. Really, as we all know, there's almost no aspect of society that doesn't find its way into the boardroom, or might not find its way into pleadings. And I encourage people who are either reporting to boards of directors or who are the board to do everything that they can to try to build in risk awareness and sort of a concept of risk resiliency, and to make sure that either they're exercising oversight properly or they're preparing the materials necessary for their boards to engage in what is being called risk oversight. So it's not that the board has to manage the risks, but it has to exercise some oversight by at least requiring management to prioritize risk management. That's the job of management. And there are so many different areas of vulnerability which get exposed in a situation like the one that we're in now. Cyber criminals are becoming more active because people are distracted by other problems. Environmental issues are becoming really critical as there are new regulations, getting rid of old regulations. There are social issues, employee safety, Me Too, and harassment. All of these things are still out there. And the need for a board to understand its role as with respect to risk is really important, and to monitor, and also to send the message to management, in terms of creating a culture about risk, is important. So as you think about our clients trying to figure out, should we open now? What happens if we open too soon? What happens if we open too late? If it's applicable, how do we deal with these broad guidance statements from OSHA that we have a duty to provide a workplace that's free from risk of death or serious injury? The regulatory regime is so fluid, it's not at all clear whether executive orders might get struck down as unconstitutional. What will that mean? How do you rely on anything when so much is in flux? And within an entity, it's really the board that's likely to have the collective wisdom, and certainly by virtue of having been around through a couple of downturns or having had other life experiences, they may have a lot to bring to bear for at least, my standard client base, where the CEOs might be, people who are just in their 20s or 30s, or possibly still, in school. So I feel like it's important to just help socialize that. There have been a number of cases that have come out of Delaware that address a corporation's failure to comply with external legal requirements. And there's the Caremark case, which is rather well known, where the holding generally was that directors can be liable for a failure of board oversight. And the court says only where, but in these current circumstances, only where might just be, instead of it being an exception, it might be we're in a place where this could happen all the time, where there's a sustained or systemic failure of the board to exercise oversight, such as an utter failure to attempt to assess a reasonable information and reporting system exists. So you would ordinarily think that's a high standard. It's not likely that that directors can fall into these traps, but we're not in normal times. Companies aren't functioning the way they should, and cases which were written in a way to provide a very high threshold for the imposition of liability, in this environment, it's like the laws of physics have been upended. All sorts of new risks and new situations and new dysfunctionalities could result in directors falling into these kinds of problems. There is the Wells Fargo litigation with respect to all of the unauthorized account openings that you're familiar with, I'm sure. And in that litigation, plaintiffs pointed to red flags about the account opening scandal that directors were allegedly aware of or should have been aware of, and took no actions to remedy it. The court in that case, my understanding is that the court dismissed the argument that, well, the red flags, if you look at them in the big context of things, were not very significant, so therefore there should be no liability. The court concluded that while the red flags might appear relatively insignificant to a large company, when viewed collectively, they supported an inference that the majority of the directors consciously disregarded their duties, their fiduciary duties, despite knowledge of these illegal account creation activities, and that gave rise to a substantial likelihood that the directors had failed on their oversight liability. And again, these cases set really high bars, but the times are different, and we don't know how cases, it may take 5 or 10 years for cases that come out of lower state courts across the country to reach similar conclusions, but that's a lot of transaction costs and a lot of litigation fees that may be spent litigating these issues across the country. There's also the well-known case of the Bluebell Creameries, where that was the ice cream manufacturer that had suffered a listeria outbreak, which caused a product recall and a plant shut down, and the deaths of 3 customers. And you can begin to imagine all of the ways that those facts could be analogized to things that could occur now. the litigation in that case arose because stockholders suffered losses after the company had to do a dilutive private equity investment. So of all the people to complain after all of the things that had gone wrong in that case, it was a derivative shareholder action based on loss of shareholder value. And in that case, it was alleged that the executives, I think it was the VP of operations as well as the directors, had breached their duties of care and loyalty by disregarding contamination risks and failing to oversee food making operations. And that was a breach, that was alleged to be a breach of the duty of loyalty. And again, how the facts might play out, one doesn't know, but I think a lot of local courts may be very particularly with elected judges across the country, may be very sympathetic to the kinds of claims that these kinds of cases have raised. And when the courts in like Caremark, for example, looked at the record from the board, they really did not, they were not really impressed by what they saw in the board minutes and the actions taken and the reports that were given to the board. So I've found it useful to try to talk to people who are on boards about how they exercise oversight, and do they need to bring in some experts to advise them? Do they have enough wisdom around the table to be able to address the situation? And conversely, under the Clovis Oncology case, which is also in this line of cases, the court there found that although you needed a showing of scienter to be able to say that the directors had knowingly disregarded their duty to monitor, because there was enough evidence that the directors had expert knowledge, they were held to a higher standard. And so I want to make sure that our boards are thinking, at least putting on the agenda, if nothing else, for their meetings, a good chunk of time to talk about these things, and not just saying, well, we'll just leave it up to the CEO, she or he will figure it out, we don't have to worry, we've hired this great person to run the company. That's not going to be sufficient. And one of the things that we discussed yesterday, and perhaps when we open this up for conversation later, I'd be really interested to hear your views on, is just, what advice do we give our clients about documenting the decisions that they're making? And I guess there are two schools of thought. My first reaction prior to hearing from some of our litigation colleagues in our chapter yesterday was, document, for every material action that you're taking as a CEO that may have, safety ramifications, document what you're doing, what you thought about, what you relied upon, what the issues were, and ditto for the board to really have good minutes that, not, she said, he said, but things that evidence in maybe more detail than you would normally use, the diligence, the duty of care, what you've done to satisfy that. And one of the comments that we got yesterday, just as part of a discussion, the devil's advocate point of view was, well, you could do all of that, you could document everything, but it might turn out, with the benefit of hindsight, that you were just wrong altogether, that, whatever you thought was going to be an important course of action turned out to be wrong, in which case, maybe you're creating a record that, that hangs you. And I'd really love to hear what people have to say about that a bit later on. One of the other topics that I like to talk to my clients about, again, in this counseling mode, is continuity of governance. And so many of my clients, they just have a single director. So under Delaware law, you can have, N number of shareholders, but you only need one director. California laws are different, but if you're a company and you have a sole director, and something happens to you, how is your company going to be governed? How are you going to, from a corporate lawyer's perspective, how are transactions, going to be entered into? How are they going to be authorized? And so I've been encouraging my clients to, consider how to deal with this situation. Should you, get a series of board meetings on the calendar and then just cancel them if you need to? Do you have people in mind who would step in to be your CEO or your CFO? Who knows where the passwords are? Who even knows the names of the accountants other than you or the lawyers? And just trying to, to the extent, again, large companies do these things, they're familiar with them, but my client base is composed of rather small, really scrappy startups. And so these are the kinds of things that, I'm suggesting, you need to grow up a little bit and think about these things while you can. And I point out to their attention both California and Delaware law allowing for the adoption of quote unquote emergency bylaws. And, there are certain timing issues. It may be under certain circumstances you need to adopt the bylaws prior to the emergency, or you can during the emergency. But I want them to understand that there are provisions that, if they're concerned about maintaining continuity of governance, that they can put into place, which may allow for more flexible procedures for calling board meetings, for establishing quorums, for designating additional or substitute directors. California allows you to put in place emergency bylaws that would allow you to modify lines of succession to accommodate the incapacity of directors, officers, employees, or agents. And they allow you under California law to deem that one or more officers of the corporation who might be present at a board meeting can basically be deemed to be directors for the purpose of establishing a quorum. And so I've wanted people to get to begin to, again, it's that sort of estate planning for your corporation, thinking about, if something should happen. Fortunately, at least in our county, there have not been very many outbreaks and people are healthy, but in other jurisdictions represented around this Zoom call, that is not the case. And these are, much more front and center for entrepreneurs. So emergency bylaws are actually statutory creations. The California Corporations Code, as well as the Delaware General Corporation Law, have a whole section which, like in the case of California, the corporate law explicitly acknowledges the right of the board to include provisions in the bylaws that relate to the management and conduct of ordinary business affairs during an emergency. An emergency is a defined term, and I suspect that we're certainly within the definition. They also grant the board the power, either statutorily, in anticipation of or during an emergency, to take a number of different actions that are necessary to make sure that the corporation's ordinary business operations and affairs are conducted or are able to be conducted. The Delaware General Corporation Law allows the board to adopt emergency bylaws, which they're only going to be in effect during the emergency. But examples of these are provisions that allow officers to call board meetings, that basically allow you to say that the directors that you get at your meeting are a quorum, even if otherwise they wouldn't be. and for providing for some relief on notice provisions. And so we can talk more about that, and we've got Delaware counsel who can also talk more to this, and we could certainly circulate the provisions of the California and Delaware code so you could see. I don't know offhand if New York has similar authority. I'm not sure that it does, but and I haven't had any corporations that have actually gone ahead and amended their bylaws to put this in. But they are things that I like to talk about. And the reason that, as I said when I started, April seems like ages ago, but my concern is that, if we go through a second or third wave of the virus, we might as well be trying to learn some of these lessons and seeing what it is that we can put in place, because I have a feeling that this is not going to be a one-time issue where you can say, well, we escaped not having to think about these things, because I've got a feeling that these are just going to keep coming back. And then it's going to be really hard for people to argue in defense. Well, I had no idea that this could happen. And that's why I didn't, plan for it, because I think we're all going to be on notice that all sorts of things can happen, and therefore we should be thinking about them. I saw that there was a question that flashed up, and I apologize for not capturing it in my consciousness. If you want to ask it again, or we can, I'm sure it can come up.
If you don't mind, yeah. So I asked the question about what exactly emergency bylaws. I think you answered that for the most part, but does that also include shortcutting the approval process? In other words, might you be able to amend in a quicker or less formal way than normally?
For adopting?
Yeah, I'm talking about adoption. It sounds like it's a limited duration. It sounds like it gives emergency powers, but I'm getting to the adoption. Does it recognize any
That's a great. It's a great question. I'm not sure whether you can avail yourself of the flexibility from the emergency bylaws to be able to adopt them. I would have to look about that. But does anyone have a sense of that? Wait, we need Steve. Wait, we need.
Unless a certificate of incorporation, at least under Delaware law, restricts the ability of the board to amend the bylaws, the board can amend the bylaws.
Right.
And that can be done quickly. And that goes with any type of thing, because the emergency bylaws are quite narrow in terms, at least under Delaware law, the kinds of things that you can do. And it's basically things like notice and availability of directors and what constitutes a quorum and such, as Bill mentioned. But the board can act quickly, but to the extent that an action's got to be taken, that typically would be an act of the board and then require shareholder approval, you can't negate that shareholder approval, which is where you can get run into some time problems.
Right.
Yeah.
Thank you.
And that's a really, the shareholder aspect is really a relevant point, because for a lot of companies, the shareholdings are fairly dispersed, and in investment documents, very often you'll see provisions, protective provisions, which say, the company can't do X, Y, and Z unless it's been approved by the board, which has to include the approval of the director appointed by Series A or Series B. Are our investors in these companies going to be functioning? How are are those people who have been designated by the investors, are they functioning? Are you going to be able to reach them? And if your documents require that you can only, amend your, increase your stock option pool if the board, including a particular designated director, approves, and you can't find that person, you can be really stymied. And if you take the action without properly approving it, it's not going to be valid, or it's going to be complicated to get ratified. So, all of these issues are, complicated enough at the company level, but when you've got investors and, all these other rights, you need to make sure all those people are with you. So we don't have a lot of time left. I wanted to talk very quickly about one of the things that's certainly of interest in Silicon Valley, which is stock options. And, I feel that for companies that have employees who are literally, risking their lives, or believe they're risking their lives to work for their businesses, basically yes, they're getting wages, but they're also doing it for the benefit of customers, and ultimately the value, redounds to the shareholders of their companies. For folks that have options, those options may be underwater, and I feel that it's important for boards to be thinking about, should they be repricing options, or if they believe that they're going to need to terminate people, while those people are still in status, can they extend the post-term exercise period so people don't lose all the equity that they had the right to buy because they're terminated and now are not getting wages. And, perhaps, if you need shareholder approval to increase your stock option plan and you can't get your shareholder approval, can you create some sort of phantom stock option plan so people can get the value that they would have gotten had they had options and exercised them, at the time of an acquisition? So I'm encouraging companies to think about that, because when and if, when the market turns around, there's going to be a lot of mobility, I think, in workplace. And, if you've taken good care of your employees, they're likely to hang with you. If you haven't, there may be plenty of other places that they can go. There are other topics that we could talk about relating to fundraising and to, what you might encourage your companies to do in terms of reviewing their contracts to make sure they understand how performance is going to work. But why don't I open it up for questions? Or comments or discussion, really, because I think there's a lot of expertise around around my screen.
Hey, Bill, it's Arnie.
Hi.
Hi. I made two notes sort of on your opening comments. One about the Stanford Library, which sounds like a great resource. I mean, one of the things we've been trying to do, and Annabelle is sort of coordinating with me, is to create our own INBLF library of materials, both focusing on COVID and more generally just practice areas. And we're going to be rolling this out really this month. We've got not a large response yet, but I intend to sort of bang people's heads, because I know people are doing it. They're writing and they're creating materials, and the idea of having these documents to showcase not just sort of this, the webinar series is one aspect of this, but having the content that people are creating. And the Stanford model, I'm going to look at the Stanford material and see what we've got, but I anticipate both COVID and non-COVID related concepts. And your point about the rule of law continuing reminds me that one of the things we've been doing, our area of practice is IP, with a heavy emphasis on copyright. And what you were talking about, sort of the emergency exceptions, most people are probably familiar with the Internet Archive, the Wayback Machine and the like, and they have created sort of like a national emergency library, which turns copyright law on its head. and they are creating all sorts of disputes with authors and publisher groups and the like. Theory that school libraries are closed, people are distance learning, and they should have access to any content they want, ignoring copyright law principles. So we're trying to educate in a series of blogs and other commentary on that point, so as to reinforce your point. There are many areas of law where, with COVID-19, people think they can run amok, but they can't.
Well, Robin Wagner was telling us yesterday, and she's our patent guru, that because the patent deadlines are established by statute, they're not things that can just be waived. And so we were discussing yesterday, if you had filed a provisional patent application, 11 and a half months ago, you've got, if you want to preserve it, you've got to get that application done. And how are you going to do that? And the USPTO can waive fees and penalties and late fees and the like, but for deadlines that have been established by statute, it's going to require an act of that legislature or Congress to amend the statute to change that. So in the patent area, it's also an issue.
Well, and there have been deadlines which are more administrative that the agencies can, in the area of copyright and the Trademark Patent Office, have been extending response dates where it's not statutory, but they have some regulatory authority on that. But it's right. I mean, the whole idea, suffer as we are through this process, there will be an abundance of legal disputes that will emerge over the coming months and whenever this crisis is over.
One of consistent with.
Yeah.
I'm sorry, Arnie, go ahead.
Go ahead, Alyssa.
No, I was just going to say that, consistent with what Arnie is talking about, I know in Delaware, one of the things we're doing is we're adopting, or hopefully with a corporate council is recommending the legislature that they adopt a provision that statutorily authorizes reliance upon those executive orders that some may question whether they work or not. At least in the corporate area, the executive order allowed people to, in a sense, postpone dividend payments for a very long period of time. So boards are nervous relying on that. So we're trying to make those executive orders, put them in the realm of, turn them into a statutory provision.
So Alyssa, can I ask you, is the Delaware Secretary of State's office fully functioning? And
yes.
So if you're filing amendments to charters, because I spoke to the filing service that I use in California, because again, I was trying to plan for my California corps that might be doing a financing and need to amend their charter to get a new series of stock or increase their capital. Expedited service in California is not possible, and the Secretary of State was running 2 to 3 weeks behind in filing certificates of merger and in filing amendments to charters. And if you're trying to finance a company, or you're being acquired by a Delaware corp and you need to make a filing in California, or it's just a plain old California transaction, your closing could be, it'll be like the old days. It'll be held up, it will close, but you won't know it will close until it closes. It doesn't really do you any good. You can't really, no one is going to issue a legal opinion saying that the transaction is closed if you haven't gotten the filing back from California's Secretary of State. So,
No, in Delaware, you could do it as fast as an hour. And firms like mine, it's still running full. And in firms like mine, we have direct access to the Secretary of State's computer. So we just do it ourselves.
Right.
So we don't need the service company. But no, the Secretary of State, they're amazing. Nope, everything's still running as usual.
Yeah, because I'm just, really concerned, and the backlog that the Secretary of State in California will have, it'll be immense. And, for people who need to get these transactions done,
It'd be hard.
I don't know how you do it.
I can imagine. I can only imagine. I also wanted just one more comment to something
Please.
you had said about, boards in their consideration of protecting the corporation. I just wanted to remind people, at least under Delaware law, our courts are clear that a board can be wrong and will not be held liable.
Mhm.
And when you were talking about the minutes,
Yeah.
what you want to show is that they look to guidance, they look to experts, maybe they retained counsel, etc. If they took into account and tried to get good advice and went and relied on it or had a choice to make, but took the time to consider it, they could be dead wrong, but they're not going to get in trouble. But
Mhm.
if there's no record of them having sought expertise or having considered the issues, then you go into the whole issue of potentially
Right. So the business
duty
judge.
of care issues,
Yeah.
like that dairy farm you mentioned. The executive committee can't possibly know, or a board can't possibly know that they're regulated by the FDA and just ignore mention that they have defective product going out the door. You can't just say, well, I'm going to rely on my management for that. So those are the extremes, but your clients don't have to worry if they're wrong. If they're trying to do a good job, they're going to be fine.
Yeah.
So
That's
Alyssa,
good.
are you in the proponent side of trying to keep your records? I think Bill talked about that earlier. We were talking about, in the issue of risk management and whether to, take careful and copious notes about everything you're doing, such as safety standards, to bring people back to work per se. Would you say that was good to have everything documented? Or then we had a little discussion yesterday about litigators were not also convinced that was the right thing to do, right, Bill?
Yeah, I mean, it depends on who you're representing, of course, but it was interesting that it provoked some very pointed reactions.
Well, the litigators note that, if you put every little thing that's discussed in minute, those minutes are subject to be considered in a court proceeding, and the board members are going to be quizzed about them, and they're not going to remember all this stuff. So you're opening yourself up to making a board member look like, I don't know, what am I supposed to remember from 5 years ago at that meeting? I think it's an art in terms of writing them. Rather than every little detail, you evidence that a discussion began at 1 o'clock on the following issues, and then you say at 3:30 p.m., the board decided to, secure some advice from counsel, get some guidance on the relevant issues, terminate the meeting, call another meeting where the lawyer, you just put on record, the lawyer was there and gave a presentation. Put the presentation in your files. You can't go in too much detail, but you want evidence that people took time and considered the relevant issues and sought to get the relevant help. But copious, I'm not a copious person either.
Yeah, I think copious was probably a bit more than I had been suggesting in the question, but yes, no, that's exactly right. I mean, it's your comment that it's an art is absolutely correct. Absolutely correct.